Call the list.
For election, item number 1.
Election. Pleadings are completed.
In this picture, we are challenging the recruitment process. That is why.
I'll admit it. When I say, I'll admit it. Pleadings are completed. Yes. So I'll admit it. I'll post it for hearing. Pleadings are completed. Heard, Mr. B. Acharya, Learned Counsel for the petitioner. Stop. Also heard Mr. R.C. Saikya, Learned Counsel, appearing for respondent numbers 9, 10, 11, and 12. And Mr. Parashar, are you appearing? Mr. K.K. Parashar for respondent number 1. Anyone else? Stop. It appears that pleadings are completed. The writ petition requires a full-fledged hearing. Let it, admit no formal notice as respondents are duly represented through their respective counsels. List for hearing in the month of February, yes. Next.
Item 2.
Counter affidavit filed.
Central Social Welfare Board. How the Central Social Welfare Board has been closed. I have several times sent emails, but no response from their side. And fact is that in this case, Central Government has some budget for them. The state government has stopped this one.
But these are your internal problems. This matter relates to pension. You cannot be denying the pension. This court, huh? Not the, Mr. Parashar, I'm sorry, I'm not getting it. The issue pertains to pension. Correct. Now, who is to give this pension?
So the salaries are paid by the central government.
Who is appearing for central government? Yes. No, board is another thing, but central government, government affidavit says it is the central government who has to ensure that the pensions are paid. Now, whether a board is there, board is not there, this court is not concerned. Central government has to. Have you filed your affidavit? Why? No, because you see, last time I think it was at your request, this matter was fixed after 2 weeks. So you try. We're giving you, Mr. Saikya, a last chance is given to the central government to file their response. I'm not on that. You see, if you are entitled, if the petitioner is entitled for a pension, the same cannot be stopped. It cannot be denied. It is a sheer deprivation of fundamental rights. You have to pay it. Now, how you pay it, you find out. You both find out. That is why I'm saying that their affidavit is required. You see, Mr. Parashar, at the end of the day, you have to approach it with a human touch. It's a matter of pension. Board may board may get closed, that is not relevant. If the service is taken and the petitioner is entitled in law, it has to be given. As prayed for by Mr. K.K. Parashar, learned CGC, learned counsel appearing for the respondent, list this matter after 2 weeks to enable the central government file their return in the matter. It is needless to be clarified that since the matter pertains to the issue of denial of pension to the petitioner, the said affidavit shall positively be filed by the next date of listing, failing which adverse orders, including personal appearance of the hearing officer, if required, shall be issued.
Item 3.
I've given a date, Hidila, date 2. After 2 weeks. 2 weeks, the date did your Krupak. Take the date. Mr. Saikya, I'm fixing a date. I fixed it on 18 December, Mr. Saikya. Your matter, I fixed it on 18 December. Yes. Yes. As prayed for, list this matter next week on a date to be fixed by the registry.
Item 4.
Affidavit has been filed. You are for respondent authorities. Who died? When? 2000? 2005. When did you apply? 2000? Huh? 2005 applied. District level? Then what happened after your application in 2005? You filed this writ petition in the year 2022. Are you carrying Debobrata Tiwari? Just keep it ready. Keep it ready. Yes. What happened from 2005 to 2022? Huh? Where? Which order? Mr. Counsel, are you ready or not? You had a, Mr. Counsel, why is it so difficult for you to answer the specific query of this court? My query was, what were you doing from 2005? Now you have straight away taken me to a speaking order of 2014. But so give me those details. When did you approach? And which is that writ petition? And where is that order of the writ petition? 31. You had filed the writ petition in the year 7323 of 17. And this court directed consideration. Who are you? You are the daughter. Paragraph 13. Yes, then the speaking order at page 27. This before you, somebody else had also filed. Yes. You are Malaya Ghosh. Yes. Hmm.
I produce, then what is this given amount? And 20.
Let's read page 27.
These are income from required with utility and education, that could be very bad. Electron, where involved with the IT, unit of peace, we have at least program CI. For doing the lead to the same information that are all the complete.
So you have been considered and your grant of consider appointment in category 3 post as and when vacancy arises.
Now,
17.
Then how many critical appointment there? 59.
Yes. Yes.
Consider my. Then what my another question, information question, whether my serial number. Then what different candidates, the stated very appointed question, please 36. For appointment.
Yes. What is your prayer in this present writ petition? Huh? 1 second. I am now, you have confused me. What is the prayer that you are seeking in this writ petition? Directing to provide for compassionate appointment. No, but already there has been a consideration. Then after that, why appointments not given? Yes. Yes. Yes.
Date of the death, criteria worship. But let us know the date of death, retirement shall be.
Where are you reading? Page 37. Yes.
But letter number 49. First,
Yes.
fix in the date of application and any other. Application may information and constitution input and. Just to control the very valid idea of appointment is date of the application. The date of death. In this context, the husband not is honorable. What I put in matter. Now, therefore, therefore, in compliance to the immunity of the candidate during the order of date of death, as per the rules, they are now 51, 51. 117.
Now they've made use 151.
How they
No, but this is not challenged. Have you challenged this? You have not challenged. But this is not your challenge. Whatever, but you have not challenged it. You have simply made a prayer to provide for compassionate appointment. This court has already granted that prayer earlier and have asked the respondent to consider your case, correct, in terms of seniority. They have considered initially they put you at serial number 17. Now by this order, they have put you at serial number 151. So you see, you have a grievance against this. Yes or no? Now, if that is your grievance, then this has to be challenged. How can you maintain this writ petition and seek for the same prayer without challenging this? Mr. Counsel, have I understood the issue correctly? Because if this is what is the grievance, then where is the challenge? If you are not ready with the answer, you go through it. I'll pose this matter next week. You have you ponder over what the court has just spoken. I have understood your contention, Mr. Counsel, but first of all, there has to be a challenge. All right, I'm not saying that what you're saying is not correct. Let me assume that you are correct. Where is the challenge? What is your relief? Have you challenged this? Then, as prayed for, list next week on a date to be fixed by the registry.
Item 5.
Daubura. What about affidavits? Who's appearing for the respondents? Yes, are you going to file your affidavits? No affidavits. Why? So say that. Just now you said no affidavits. How much time you need? As prayed for by Mr. A. Chakraborty, Learned Government Counsel. List this matter after 2 weeks to enable the respondent file return in the matter. List on such and such date.
17. 17 December. Item number 6.
Mr. Saikia, the rejoinder is filed. Rejoinder is filed. No, but last order appears that rejoinder, if required, they would file. That's why, but I don't find any rejoinder on my record. Are you filing a rejoinder? Why is it become so difficult for counsels to take a call whether a reply or rejoinder will be filed nowadays? Additional affidavit? Huh? Additional affidavit? No, when have you filed? Additional affidavit to असने की सोचो ये index से देखवाना है. Let's see. Is there an additional affidavit, Mr. Dhar? I don't find on my record. No, because my record doesn't say. There is no additional affidavit in our records. Neither the government has been served. I think it is only in your file. Maybe your junior has not filed it. Please check. Right, you verify. As prayed for, list this matter after. Mr. Soikia, please sort it out outside. As prayed for, list this matter next week on a date to be fixed by the registry. Next matter. Next matter.
7.
Yes, Mr. Manan. Reply is filed on 3/3. Ready for hearing. What is the issue involved?
and they have started with the regular inquiry. My case is that initial preliminary inquiry is already at street inquiry. So then that's part of the regular inquiry and complaint what is the complaint, what are then I and this is that's what that was not done. And
They relied upon the preliminary inquiry.
what is that have regular inquiry, second part is the regular inquiry. Where you, as per the evidence is there, they have to give us an opportunity to the patient and certain things that happen.
Show cause not given.
That was not given, but they initially put some letters to me to produce basically my salary, whether I have a car or not, or what is the everything. But that was 7 years ago. Till date, nothing has discontinued like this. So I came before this court. They filed the application. The affidavit, they said that initially there was some issue because I was transferred from one place to another, so transferred to an MDI. So in different places, so they are gathering the
Information.
and they cannot even say what is the state as of. They said that we will have to go know what is the state as of. That is the affidavit filed sometime back. Then my case is that 7 years cannot continue for infinity. Because I have 56 years ago, another 4 years, I'll be back. So, particularly as per the SOP of the
This is the first writ petition, right? So this affidavit that you're referring is filed in this writ petition itself. Yes. So your prayer in this writ petition is for concluding the inquiry which has been started.
setting aside. So that was not
Setting aside the quash the regular inquiry. Yes.
set aside was the regular. Because that
But
inquiry.
Ms. Bhattacharjee, what is the status of this inquiry? The 2016, huh? No, but then you have it. I'll post this matter on Friday. You find out. Why? All that you need to apprise the court is the status of this inquiry, because if you're not interested, we'll quash it. Because if you're, that is all. You can't keep this inquiry hanging in the head of the petitioner. You have to finish it. Right. All right. When? Heard Mr. Y.S. Manan, learned counsel for the petitioner. Stop. Also heard M.S.M. Bhattacharjee, learned additional senior government advocate for the state. Stop. List this matter again on such and such date. On which date M.S. so-and-so, learned state counsel shall apprise the court as regards the up-to-date status of the regular inquiry number 60 within bracket 11/2016, which is alleged to have been initiated in the instance of Directorate Vigilance and Anti-Corruption Assam, Vide number DGVA/R1/2016/3408-A, dated 9/11/2016, issued by letter dated 16/3/2017 by the Superintendent of Police Vigilance and Anti-Corruption Assam. Stop. That should be sufficient.
Step 8.
You want this to be listed along with? As prayed for by Mr. V.P. Sharma, list this matter along with PIL. You want this matter to be listed along with a PIL. How can I give you that order? PIL is not before this court. As prayed for, list this matter after 2 weeks on a date to be fixed by the registry. Take your instructions properly. And in that situation, you will have to make a mention before the division bench and get this matter tagged along with the PIL.
Item 9.
Yes, Mr. Das? That has to be heard, Mr. Dhar. Records. Your records looks voluminous.
Yes, madam. It will take time, madam. 22 hours, madam.
2 hours.
Madam, I have to
I think it is better to have it fixed on a regular day. Yes, Mr. Das?
But the other side, it comes, big volume, it will take 2 hours and all. Matter has to be hard, finally, or not hard matter. Your
It is
argument-
still at the admission stage.
Madam, that's the issue rule. Without issuing the rule, madam, cannot, yes, madam.
All right, we heard Mr. BD Das, Learned Senior Counsel, assisted by MS R. Deka, Learned Counsel for the petitioner's term. Also heard Mr. Ardhar, Standing Counsel, PWD. It appears that the records as called for has been received by the office of the Learned Counsel, PWD. Stop. It further appears that the pleadings are complete. It appears that the matter requires a full-fledged hearing. Admit no formal notice as respondents are duly represented. List next week. When do you want it for hearing? Hearing day, Thursday? List on Thursday for hearings. Yes, 5th December. Any problem?
Friday, which is difficult, madam.
5th is Thursday, I think.
But
Madam Chair,
Yes. Yes.
it's the facts.
What is this matter?
This is a matter.
Hmm?
Taken up to it.
What is the matter?
Such that in my entire life. After I retired, they extracted my work for 2.5 years.
They extracted?
But after I retired, after I reached the age of superannuation, they gave me the rank of special statistical officer, and they extracted my work for 2.5 years. They paid me for the almost the entire amount except for the last 8 months. They had submitted all the the bills and everything to the transport department. For some reason, it remained by not entangled in bureaucratic hurdles. And when the time for the payment came, they said, no, they consider this last 8 months as voluntary, meaning thereby as a free service. But had they intimated me before, I would have definitely refused to work for such an exploitative kind of an environment. I can just clear the facts.
Yes. Just before going to the facts, prayer is at page 23.
Here, page 23 or your.
So withhold the area salaries. So this, the issue is about withholding the area salaries from November 21 to June 2022. This is the period in question. And to construe the services rendered, so that is the impugned decision as follows. Where is that decision?
Page number 113, madam.
113.
Page number 100.
Yes.
They issued this letter. When I submitted representation for payment of my salary, they issued this letter and they said that this term would be constituted as voluntary.
So what was your appointment?
Initially, I was appointed as an LD in 1988.
Hmm.
In 2001, I was promoted as an internal auditor. In 2003, I became assistant statistical officer.
You were a regular employee
Regular.
and you were supposed to be superannuated when?
December 2020.
December
2020.
20.
That letter your lordship will find.
After that, you wanted an extension.
They give
They
me-
extended it till October 21.
They gave me an extension. Total extension was from my lord till June 2022.
22. By which order?
Your lordship can see page number 37.
So this is the period for which they are now not giving you the arrear salary.
But they take that amount. Only the last 8 months.
All right, let's see this extension. Because I assume that they will say that this extension was not perhaps proper.
They will say that it was not explicitly spelled out.
So earlier, first show me that extension.
The first extension you find at page 38. ma'am.
Did that spell out about the salary part?
They haven't. That your lordship will find.
No, in page 38, 31st December 19 is hereby re-engaged on contractual basis for a period of 11 months on contractual basis with a fixed monthly remuneration. It is mentioned here. This order mentions with a fixed monthly remuneration. Correct. Now, this expired when? 11 months.
11 months. So it will be filing on when next year, November. November 2020.
November 2020. Any further extension?
Which your lordship will find at page 40. ma'am. Page 40.
Is hereby extended. Now, this doesn't talk about any remuneration.
Is hereby, no, it says if the other terms and conditions will remain same, page 40.
Okay. Okay. So then, page 38 terms are same.
Same. No, 40.
Yes. Then, now this will expire when?
This will expire on why not, November, 11 months. So we will January, February, March, April, May, June, July, August, September, October, November
November
2021.
21. After this also extension? No. What do you mean by no explicit extension?
Let's just
No,
place
but
one-
this is very clear.
let's just place this document. ma'am.
Hmm.
If your lordship kindly sees page 81. Page number 81.
You see, Mr. Counsel, if you are carrying on after expiry, it would be at your own risk.
But
Page 81.
wait,
All right, all right.
11th May, your lordship kindly note the date, 11th May 2022.
Yes.
I worked till June 2022. This is by the 11th May 2022, and at the bottom your lordship will see the author of the letter is the MD ASTC. And your lordship will see the letter has been addressed to the Joint Secretary of the Government of Assam Transport Department. Subject, your lordship will kindly know. Engagement, re-employment of staff under ASTC. Sir, reference above. I am furnishing here with the information regarding the engagement, re-employment of staff under ASTC as below. And if your lordship kindly skips to the point number 4, payment of remuneration on re-employment after retirement, remuneration paid as per OM issued by the Government of Assam, Department of Personnel, Assam Secretariat Civil Dispute by number so and so dated 15 July 2000 as last pay minus pension public lump sum amount. And your lordship will kindly
Serial number E. 69026.
below your lordship, this is for your favor of information and necessary.
No, but this 69 is the per month. And this otherwise you have got it after May 22.
I have got it till 2021.
That's because the order of 3rd December is for 11 months, which expires in November 21. And therefore, till then you got it. After that, there is no order of extension, formal order. Then how are you entitled? Where does it show that thereafter also will be covered? Yes, it talks about engagement, re-employment. Engagement, re-employment, you have already shown me there are 2 orders. Correct? Hmm. 20? Hmm.
draft cabinet memorandum which was sent.
For engagement, re-engagement.
Correct.
Does it says that after November 22, November 21, you will be retained and you will get the same terms will be applicable? You have to show me that unless and until, otherwise, where is your right? That is the only thing, because you see, first you have to show me that there is a right. And if suppose there is nothing, there is no formal engagement, are you still entitled? You have to satisfy these 2 points because these are the issues that are being raised. That is,
This letter dated 11/5/2022, when they conjointly with this draft memorandum dated 23/6/2022. For this draft memorandum, which will actually find it at page 82 minus.
yes.
Reference above, I am furnishing here with draft cabinet memorandum.
Let's come to 83. Yes, where here they have said that beyond engagement, if your service is taken, they are entitled to pay. Where is it?
That page 85, your lordship will kindly see my page 85.
Yes,
There's a chart in the middle.
yes.
The employment.
Here also that 69026, re-employment of retired person on contract basis with fixed monthly remuneration. So they refer order of re-employment 31/12/19.
1/10/2021, page number 86 is the lordship.
One second. 30, they are referring to 31/12/19. Which is this 31/12/19? Is the first order of re-engage. Is that the first one? Yes, it is the first one. So they are referring to that. And you see term contract 31/12/19 to 31/10/2021. Then after that, see, Mr. Borwa, we are concerned post November 21. We are not concerned pre. That part is covered and you got.
Yes.
Had your case been that something is still pending, it would have been a different matter. Now show me. Hmm.
Now, there is no doubt the fact that I have been
That is a different thing.
the two aspects of it.
Hmm.
Firstly, my lord,
Now you see, if you are working, they have said voluntary.
they have said after I have retired.
No, but where is the order of re-engagement or extension? You are aware of the law. You yourself is offering your work. Why? Who stopped you from stopping the work? You could have stopped.
That's falling from your lordship is, my lord, there's no quarrel about that.
Hmm.
That, yes, there's no extension.
Hmm.
Your lordship, my lord sees from the other side, he has been extracted his word. And your lordship.
You are now appealing to my heart. But I have to decide from my mind.
Thinking from your mind, my lord.
Hmm.
What I'm trying to impress upon your lordship is,
Hmm.
your lordship is aware, the law laid down by the honorable Ecclesiastic Court is very clear on this.
What?
That when a person works, it is not implicit that it is as the nature of bounty. Now, it is placed by your
See, that would depend on the context of each case. Here is a clear case. The nature of re-engagements are very clear.
very clear.
And after the engagement, after it was expired,
Your lordship sees my pleadings and paragraph.
before I go to your pleadings, let us kindly draw my attention to the affidavit of the government where they have taken this stand.
Your lordship will see page number 116, page number 116. Page number 116,
Yes,
paragraph 6.
yes.
So this is the stand of the corporation. It says that the deponent being the managing director of the corporation constituted statutory. Next to state that the method of re-employment of the retired employees of the corporation in compliance with the resolution taken in 179 Board of Directors meeting of STP was forwarded to the government in Transport Department for taking no necessary action. But no reply has been received by the office of the deponent till date.
Kindly see para 7. Kindly see, that is a very dangerous paragraph. You have not responded to the committee members' request of handing over the charge. Mr. Porwa, I cannot travel beyond record. This is the stand of the government. Please read para 7.
Paragraph 7,
Yes.
it
Read.
states that the deponent begs to state that an office order was issued by so and so, by which a committee was constituted by comprising of 3 committee members to hold and take the charge of the statistical officer from the petitioner within 25 days. As the contract service period of the petitioner would expire 31/10/2021. The committee members approached the petitioner on 31/10 for handling. As stated by the committee members on record, the petitioner did not respond to the committee members'
Request.
Now, my reply to this, Your Lordship will find.
Let's complete that paragraph. Let's not rush.
And as the charge was not handed over by the petitioner to the committee members, and
Hmm.
upon subsequent request made by RD Nath, committee member, so and so for handing over the charge, the petitioner misbehaved with RD Nath and went to the chamber of MD STC, wherein he requested the MD to allow him to stay in STC. The petitioner also informed that he will offer his service to the ASTC voluntarily without taking any remuneration, as was stated by the committee members on record. Thereafter, the petitioner disobeying the office order, continuing to use the official card and of other electronic.
Mr. Borwa, this affidavit is inviting trouble for you. Because if that is so, the entire writ petition appears to be an abuse of the court process. You see, you are not handing over the charge and there is no extension order, and yet now you come before this court and you say you pay me the area salary. Where is your case? Where is your entitlement? It appears from the state government affidavit, which is filed on oath, that you have not handed over. Where is your reply to paragraph 6? Paragraph 7. Reply to paragraph 7.
Page 139. Page number 139,
Yes.
paragraph 7.
Yes.
Can I just read on?
Yes. Yes, please.
That with regard to the statements made in paragraph 7 of the affidavit of opposition under reply, the deponent humbly begs to state that same are incorrect, baseless, and completely misconceived. As such, the same are categorically denied. It is categorically denied that the committee members approached the petitioner for handing over the charge of the statistical and monitoring section. When the committee members never approached the petitioner for handing over the charge, the question of handing over the charge to them does not arise. As is now an admitted position after the exchange of readings, the petitioner was regularly entrusted with various works till June 2022. It is also categorically denied that a subsequent request was made by.
Where is the question of someone even approaching you for handing over the charge when your term has expired? Assuming otherwise. Where is that situation?
It is.
Yes.
But it is also categorically denied that a subsequent request was made by one Sri RD Nath, committee member to the petitioner and the petitioner misbehaved with the Sri RD Nath. The said statement is a completely false as well as incorrect, and the same has been made as an afterthought. It is for this precise reason that the authorities have failed to place a single written communication document to substantiate the fact that Sri RD Nath had requested the petitioner to hand over the charge. These are official matters. It doesn't go verbally. If they need a charge, all they require to do is give me a letter stating that please hand over the charge. It's as simple as that.
No, but where does that requirement come when admittedly your extension is over? Are you not supposed to vacate it?
Because
What is the procedure? You are supposed to vacate it. This is not a transfer.
they ask me the charge.
Now, if you are not handing over and you say, let us take a very hypothetical situation. Tomorrow, a person's term expires. He superannuated, and he doesn't. The officers have not sent him a formal letter, and he continues. Can he now say that no, I am continuing and I am working, so you give me wages? How can it be done? You see, in your case, now beyond superannuation, you don't have a right to continue. That is a discretion of the state government. There is some rules, Mr. Das. There are some rules. So, no, that there is under some rules. The extension is given under some rules. Which is that rules? Please find it out. So that is a discretion of the state government, right? Now they have exercised that discretion twice. After that, they don't want to. You can't force them. And secondly, you without that extension, you can't continue. If you are continuing, that is illegal. And anything that is illegal, under Article 226, you are not entitled for any relief whatsoever. I'm sorry, I'm not inclined to allow this writ petition. Mr. Borwa,
Definitely. I understand your lordship's,
unless and until you show that there is an order extending your, that is apparently not there. Admittedly, there is no extension.
what is there, my lord?
You see, you will be inviting cost, I'm telling you. Because I am finding this writ petition an abuse of the court process. Because it appears you're not handing over. Now you're coming by way of a 226. Where is your right? It's illegal, apparently illegal.
Right, this one.
Yes.
Now, here is a case, as I have pointed out before your lordship, that I had retired on 2020 December. Now, there was I will show from the records, there was a dearth of senior.
I'm not concerned. Mr. Borwa, I'm not going into all that. I am sufficiently warning you. So please accept the warnings, otherwise you're inviting. No, no, not other day. I'm dismissing it right now. What is there to keep this matter? Your
Give it up to your lordship. Where this place, certain whatever thing I feel are the facts.
you've already placed. What more? All right. You have time till 4:30. Not beyond that.
Where I had my superannuation, the lordship sees page number 37. I just placed page 37. This was the letter of, in page number 37 on 26 December 2019, they write me a letter saying that Sri Bhavanto Soitya is hereby released from ASTC with effect from 31/12/2019 afternoon on attaining the age of superannuation, that is 60 years. But at that point of time, my lord, there was a dearth of senior officers in ASTC. Admittedly, there was. And that is the precise reason.
For extension.
That is the precise reason why they expected my service.
And they give you the money
And they gave me my money
Hmm.
for the months
for which they were extension.
for which they were extended. Explicit extension.
There is nothing, there is no concept in law about explicit or implicit extension, Mr. Counsel.
Now they have.
Where is the provision?
Since there was a dearth of signal, I was. Now, if your lordship sees, now the period in contention is November 2021 to June 2022.
November 21 to June. Hmm.
This is the period of contention. The other ones have been cleared. Now, if your lordship sees, I have placed materials on record to show. If your lordship kindly sees page number 47.
Mr. Nair, do you remember that citation of Apex Code where I think it was in context of regularization case where it is said if the appointment is illegal, no relief whatsoever, even salary, one is not entitled. I think that is the one. Can you, Ms. Bora, can you kindly just check in your Google or your, if you have the apps? Yes.
Page number 47 for a moment. Page number 47. Page number 47 for a moment, madam. Page 47.
Yes.
Review.
Yes.
The reference above, I am directed to inform you to review meeting will be held on 18th November 2021 at 11 a.m. And down below, serial number 9, your lordship will see is addressed to me, the SO. Special officer. Now, If your lordship kindly turns to the next page for a moment, page 48. And your
Yes.
lordship will kindly note the date. It's 18th November 2021. Page 48.
Yes.
And serial number 11, your lordship will see. Sri BK Hanoi, SO,
Hmm.
special officer. 1811. Now, if your lordship kindly turns to page 51,
You were present in this meeting.
he present the entrusted various word. Page 51. Page 51, the last three
Mr.
lines.
Borwa, these letters will be of no, it will be of no relevance for the simple reason that there has to be an extension and you cannot, you don't have a right. As a matter of right, you cannot claim, correct? 2 extensions they have given. Third, there are no extension. Apparently, that is the admitted position, which you also agree. Now, in that situation, you're not entitled for anything. Now, you are working at your own risk. How can this court, while exercising powers under Article 226, give you any relief? You yourself is voluntarily offering your work, and then you cannot turn around and say they are exploiting. In fact, on oath, there is one, they have taken that stand that you have not handed over, though you in your reply, you are denying, but that is a disputed question. How can this court under Article 226 enter into these correct? No, but even if I do not go to that dispute, it appears that you have not handed over. Correct? That is their stand. Now, that being so, that is why I am repeatedly saying that this writ petition doesn't appears to have been filed bona fide. Because you yourself have offered to work. Looks like. So I don't think you are. No, it is not about making up my mind. I can only decide a case on the basis of the record. I cannot travel beyond it. And there is an admitted fact that there is no extension. Now, if there is no extension vis-a-vis the pleadings which are on record, it appears that on your own you have worked beyond November 21.
If there is no extension, then why am I not making any point?
No, you are also working. Where had there is no document showing that they are making you work, Mr. Borwa, mind you. There is no document. On the contrary, the stand of the government is that they have asked you to hand over and you're not handing over.
Because the June letter, 18/8/2000.
I'm sorry, because if you want the relief, it has to flow from some document. You must show me you have a legal right. Where is your legal right? I think I've given you sufficient time, Mr. Counsel. Yes. Yes, yes.
It makes from this document. On page 51, your lordship see in the bottom, TG BK Hanoi, SO, stated that statement from ISBT Guwahati Division is not received timely, resulting problems in finalizing performance of the corporation in the division. So that means on 1811 till 1811, I was regarded as an SO, a statistical officer. And if you
Mr. Borwa, there is one way where I am not at all inclined, so I'm going to dismiss the writ. However, I can give a liberty to the respondent to consider about the area salary for the period admittedly that you have worked. That liberty I can give to the respondent, Mr. Das. Because you see, it appears otherwise he has worked. This court is not convinced with the argument of the petitioner that he's entitled for that area salary because there is no document on record which has been placed to show that you have allowed him the extension, correct? On the contrary, your pleading shows that he has not handed over. So, but however, without going into all this, I can reject the writ by saying that there is no extension. However, admittedly, it appears that he has been working for the period November 21 to June 2022. So for that period, if a representation is made, the authorities may consider in accordance with law, because he has worked otherwise. So keeping that in mind, if a special case is made, you make out that liberty. I may just keep it open.
authorities are going to reject my application for sure.
You see, I am rejecting it because there is no order of extension. However, I will make it clear that it has come because Mr. Das, you are not also disputing to the fact that he's been working from November 21 to June 22, correct? That is also another admitted fact. So therefore, in that context, I am asking the I am giving that liberty to the respondents. Only in that context, because admittedly you've been working.
The only thing is
Where
that
he has stated that he will go for it.
Where is that? Where is that record?
Right now,
That record should have been, you should have brought it on record.
are you putting the record which shows that
let the authority decide.
document which says that I have.
Mr. Borwa, what is the point after court investing so much judicial time in a matter and if the matter cannot be disposed of? We have made everyone wait. And there's nothing much more to be done also.
Dismissing the matter on merit. Then, my lord, that if your lordship is relegating the matter to the authority to decide on that unpaid amount, then I think, my lord, if your lordship gives a decision, I think it will, my lord, prejudice me in some manner. And if your
In your affidavit, have you said that he is voluntarily working? The writ petitioner also informed that he will offer his service to ASTC voluntarily without taking any remuneration, as was stated by the committee members on record. When can you have the records? When can you have the records? Monday? No,
Corporation to review.
you see, if the records indicate this, then there could be a different way of disposal also. Heard Mr. A.K. Borwa, right? A.K. Borwa, Learned Counsel with the petitioner. Also heard Mr. R.M. Das, Learned Standing Counsel, ASTC. And what about MD Bora? She's appearing for someone? And MSMD Bora, Learned Standing Counsel, Transport. It appears that the issue involved in this writ petition is the area salary for the period November 21 to June 2022. Stop. Though it is apparent that there was no extension of service after 31/10/2021. Correct? 31/10/2021, the petitioner was continuing with the work for which period by way of filing this writ petition, the salary has been sought for. Stop. It appears that the stand of the respondent authorities is that though the respondent authorities was approached for handing over the charge after the expiry of the extension of service, the writ petitioner did not respond, and thereafter he informed that he will offer his service to ASTC voluntarily without taking any remuneration, as was stated, without any remuneration. Stop. Mr. R.M. Das, Learned Standing Counsel, ASTC, submits that it is the records, if called for, will substantiate the said stand of the respondent ASTC. Stop. Let the records accordingly be produced before this court on Monday dated on such and such date. and list again on so and so as part third. You got that citation? You please give it to him. It is, however, clarified. No, we'll see on that day. Mr. Das, you have the record because it is very fresh in my mind. Otherwise, again, I will forget. It is clear now. You only said it is there in the records. Now,
Item 11.
reply. As prayed for by Mr. S.K. Das, Learned Counsel for the petitioner, list this matter after 4 weeks on a date to be fixed by the registry to enable the petitioner to file rejoinder to the affidavit in opposition filed by respondent number 4 on 29/5/2024.
Item 12.
Then appears for the parties when called list after 2 weeks on a date to be fixed by the registry.
Item 13.
Then appears for the petitioner when called list after 2 weeks on a date to be fixed by the registry. Where? In item 13, Mr. Ardhar enters appearance on behalf of the respondent PWD.
Item 14.
As paid for by, you are for the petitioner. Ms. Bhattacharya, this is that dismissal matter. As prayed for on behalf of the learned counsel leading the brief for the senior for the petitioner, list this matter when? Huh? On a date did you of December on such and such date? Give it on that day. Sorry. Appeal provision is there. All right.
12.
Hmm?
Item number 12.
You are for the petitioner. Item 12 for none appears to Gusaidiba as prayed for by Mr. R. Borwa Korpela. Same 2 weeks this low.
Item 15.
All right. Why do you want Mr. M. Sharma, Learned Counsel, appearing for the respondent, seeks accommodation in the matter as his name has not been reflected in the cause list. Cause list. Stop. Prayer allowed list. January. List after 2 weeks on a date to be fixed by the registry by reflecting the name of Mr. M. Sharma, Learned Counsel, appearing for the respondent in the cause list.
Item 16.
IA is there. Mr. Dasgupta. This matter perhaps will take time. I don't know why these matters have been fixed before this bench because this is a temporary arrangement that has been done at the fag end of the day. It should have been probably listed before the regular bench. What is the matter?
Matter is number 6. You can take up it better as in any other thing. But actually, additional in the executive director of HCI. He is a retired.
He is a retired
Retired.
employee.
the year 2008.
Hmm.
At that point of time, there was a departmental inquiry, not at that point of time, but there was a departmental inquiry. Which ended me that EPC, his promotion was kept in Singapore. Subsequently, he was been exonerated from the departmental inquiry. Now, by this time, you is also retired. Now, or he was also promoted to the post, but not from the duty. So, I think you are not in the mind whether he is entitled to get the benefit from the date when I have
Notional promotion.
because of it. The date, yeah, but tomorrow. I have prepared a note also.
Main case to put it, sir. You are right now. You are the main case is being taken up, right?
The presentation, I have prepared a note on that date when I gave to the lordship.
Note at Asani, sir.
Thank you.
Wait, 1 second. Probably it is there. Yes, sir. So later on, promotion is given.
Exactly, the promotion from the due date.
So according to you, due date is when?
That is the month of the.
As a matter of right, you cannot claim.
As a matter of fact, I
How? It's a promotion.
the field of
Hmm.
the established law.
Hmm.
And that person is promoted, but due to departmental inquiry or some criminal case, the effect of the promotion is not given. So this-
Here it was a case because of some inquiry. Promotion was not given at that relevant period. What was the reason? What was the reason?
The departmental inquiry.
Yep.
Was,
In a trap case. Later on, he got acquitted. He got acquitted.
was given. And departmental inquiry, which was initiated against me, that was also dropped.
In your favor. Because you got the acquittal.
And departmental inquiry was also dropped. Now the only remaining question is that whether I am entitled to have my promotional benefit on the date. I think it was a day or something like that. So what you can tomorrow or day after.
Day after tomorrow? Next week. Okay, as prayed for, list this case again, next week date, as prayed for.
17 and 18.
Yes, next week. On a date to be fixed by the registry. Yes. What is this, Mr. Das? Dismissal from service? Hmm. Yes.
The petitioner, he was serving as superintendent of excise. An applicant, the person who intended to open an independent shop, he submitted an application seeking permission. That application was rejected by the petitioner. Then he again submitted an application. Since after an inquiry, the petitioner rejected the application, the petitioner didn't contact the petitioner. And the commissioner issued a communication asking me that, what have you done with this? Then, petitioner replied that we have caused an inquiry and there were some, shortcomings in his application, so we have rejected. So that event got, after, that particular person, he, laid a trap and with the help of the police and came to the house of the petitioner, trust some money and he left the place.
What he withdraw some money or
Trust some
huh?
money,
Trust.
There was no independent witness, nothing. Now, pursuant to that criminal case was registered, the petitioner got arrested, he got jailed, and thereafter DP was initiated. Now, in the department proceeding that was initiated by, I'll just give you the date, show cause notice dated 28/10/2016. That was the first show cause notice. Now, there was no list of witness, no list of documents. The inquiry that was conducted absolutely forcible. I show the report of the inquiry officer. Nothing was recorded therein. And the inquiry officer, held the charges to be proved. The matter was, sent to the disciplinary authority.
List of witnesses was not given.
It was not even there in the show cause notice. Show cause notice did not contain even the list of witnesses and documents.
Where is the show cause notice?
Yes, that was the first case 65.
What do you mean by first show cause notice? After the
Yes,
this
Ministry of report.
Hmm.
But thereafter, that inquiry, he held the charges to be proved. The matter was sent to the disciplinary authority. Disciplinary authority decided to hold a de novo inquiry. Office is aware that there is no prescription of de novo inquiry in Assam Service. There are judgments of this on.
but if they disagree, they may give you the reasons of disagreement. Hmm.
There is no provision for de novo.
Here they went for a de novo.
And they even second show cause notice. And this show cause notice contains this kind list of documents and witnesses. And more
You rectified.
And more interesting, this show cause notice was issued by the inquiry officer, not by the disciplinary authority. All sort of mess.
How can the inquiry officer issue the show cause notice?
Again, they have proceeded with the inquiry, and this time the inquiry officer will not recorded a finding that, demand of money was not true, but acceptance of money was true. And on that finding, the disciplinary authority imposed the penalty of dismissal.
You see, this court of course cannot go into that part. That is a matter of appreciation of the evidence. That is, you have to show there is some evidence. Now the weight of that evidence cannot be weighed in an Article 226 matter. But procedural, I'm with you. So you can show me that if you can show me that there has been some procedural lapse, that opportunity has been not given, then of course, or if there are any statutory violations. So
Yeah, but if the evidence. is
sufficiency of evidence, this court will not go into.
sufficient to-
No, I have understood. You are saying that there is no evidence to show that that money was demanded. Only is that the money was accepted. Only that part.
your
That is a matter of evidence,
true.
and it's a disciplinary inquiry. Here it is preponderance of probabilities.
Said, whatever evidence he collected, he derived a conclusion that, demand of money was not true. If there is no demand, demand and acceptance is, your, incidental to each other. A person,
Difficult. I'm appreciating your argument, Mr. Das. Yes, yes, of course. I'll be happy to be persuaded.
this is the, basic factual background.
Hmm.
there are serious procedural errors because firstly, the inquiry officer, issuing a so-called
No, is that fatal? Is that fatal? Do you have any authority to show that is fatal? Because if I recollect, some you see, because correct, correct. Yes, at the end of the day, the object is that you get an opportunity, whether it has been given by the inquiry officer or somebody else. But you know, that's why I'm asking. You correct me if I'm wrong. If there are any authorities, you show it to me. Because in cases of in context of labor court matters, management and workmen issues dismissal, there certain times these issues comes that the management is doing everything. And I think if I'm not wrong, even they're in a situation where um, the notice ought to have been issued by the management, but it was issued by the inquiry officer. These grounds, I think there are decisions, old decisions of 50s, 60s, where the apex court have said that for that the inquiry does not get vitiated. So that is why I'm asking if you have any, you have to show me procedural. For you are saying there are serious procedural lapses. Now, ABC, what are those serious procedural lapses? One, if I have understood you correctly, there was a de novo inquiry, right? Number two, you are saying pursuant to the decision of de novo inquiry, a notice was issued, which was issued by the inquiry officer, and he's not competent. Number three, you are saying in that notice, now they have provided you all the list of witnesses and everything, which earlier notice did not contain. And also another that the inquiry officer has been changed. These are your grounds. These are your grounds. And then finally, perversity is what? If it is acted without evidence, correct? Here it appears that some evidence is there. The acceptance is there. Demand is not there. Now that, of course, but as far as the procedural, if you are carrying the authorities, it is all right. Otherwise, you show me this,
so far as this acceptance is.
because I think this is the, Mr. Goswami, have I understood the issue correctly? So then you show me authorities that the inquiry officer cannot issue the notice, it will vitiate. No, but where are those authorities? You show me. If you are not having it today, we'll have it another day. But all right, then we'll have it another day. As prayed for. All right. As prayed for, list this matter again next week on a date to be fixed by the registry. No, next week would be first week of December. You're not available? You're there. Tuesday. Thursday? Give Thursday then. Thursday. You get all of those authorities then. But because those are things which you'll have to show. At the end of the day, the test is whether the inquiry is vitiated or not for non-following those. Otherwise, those are standard requirements. You see, you don't have any act guidelines. I don't think there is any rules which says that what the inquiry officer can do or cannot do, or does that say who is going to provide and all that? So, and non-compliance of the same, whether it will vitiate. At the end of the day, the test is that. All right. Yeah. Yes, of course. If the evidence is not relevant, it would be perverse. But Mr. Das, here, admittedly, from whatever you've said, acceptance is there. All right. All right.